It's important to note before I get into it that this is just a brief overview and introduction into the family courts, so it's not formal legal advice, and if you have particular issues that you need advice on, I would encourage you to see a lawyer about that. Tēnā koutou katoa, o tira tēnā tātou katoa, ko Waimirirangi tōku ingoa, he uri tēnei no ngā iwi whānui o muri whenua, no taranga moana anō hoki, he roi a hau kei tāmaki, e noho ana e mahi ana hoki. Kia ora everyone, my name is Waimirirangi. I'm a lawyer based in Tāmaki Makaurau, Auckland. I'm just here to talk a little bit about the family courts, the family court process and the principles that guide some of the decisions that's made in the family courts. It's important to note before I get into it that this is just a brief overview and introduction into the family courts, so it's not formal legal advice, and if you have particular issues that you need advice on, I would encourage you to see a lawyer about that. So in terms of the family courts, there's lots of different acts that govern decisions and processes that fall under the family court jurisdiction, but in terms of what I'm talking about today, it will just be decisions made under the Care of Children Act. So the Care of Children Act is a piece of legislation that governs, in essence, decisions about how care arrangements and guardianship disputes are resolved between parents or other guardians. So for the purpose of today's kōrero, we'll just be doing an introduction in terms of the key principles and some of the different functions in the family court process. So under the Care of Children Act, all decisions that are made by a judge or anyone else who's involved in that process must give effect to the Section 4 principle, which in essence says that the welfare and best interests of the child or the children must be the first and paramount consideration in his or her or their particular circumstances, which is a bit of a mouthful, but in essence that just means that the decisions need to be what's best for the kids or for the kid. There are different principles that the courts must consider when they're giving effect to that principle, the paramountcy principle, and those are found in Section 5 of the Act. Section 5 has a number of different principles, but they're not the only principles that a court or that a judge will consider. But they are things that a judge must consider if they're relevant in that child's particular circumstances. So if you look at the Act, Section 5A is the only principle that is a mandatory consideration or that must be mandatorily met in terms of any orders or decisions made. So Section 5A has to do with the right of a child to be safe. So safe from family violence, safe from any other thing that might be considered a risk to that child's safety. So you can see that in the wording, it says must. So that's how you know it's a mandatory consideration. The other principles that a judge or that the courts might consider in Section 5 include the right of the child to have his or her care, development and upbringing primarily managed or responsible or primarily manage or have their parents responsible for that role in their life. The other principles include the right of a child to have his or her parents cooperate and consult with one another and facilitate with one another, in terms of guardianship and care arrangement decisions. And usually Section B and C, which are the two principles I just talked about, kind of go hand in hand. It's really, in practice and reality, it's two parents making decisions together, both responsible together to raise and care for your child or for your children. So the other principle in Section 5 is Section 5D, which has to do with continuity. So what that means is that as much as possible and where reasonably achievable, you try and keep things as normal and regular for the kids as you can in terms of the status quo. So what that might mean is if they've been in a shared care arrangement, or they've been living here with mum and dad, and this is something that's felt normal for them and has been normal for them, that you try and keep that status quo or that normality or that continuity, I guess, as much as possible when decisions are being made or when changes are considered by parents. Another principle in Section 5 of the Act is the right of a child to have a relationship with both of his or her parents, the right of the child to have that relationship with their wider family, whānau, hapu, iwi, or family groups. So really that's just about thinking about all of the people who are important in that child's life. So nanny, uncles, aunties, koro, whoever else might be important members of their family or whānau, just considering how you're preserving that relationship. And normally the courts don't need to intervene because those are things that just come naturally in care arrangements between parents or when parents are together. The other principle that's considered is the right of a child to have their identity strengthened and preserved. So in the Act, that refers to the child's culture, their language or religious affiliation. That's not limited, so there are other things that are important to that child's identity that could fall under that principle. But yeah, some of those things might include whether they're baptised in one church or another church, whether a child is raised bilingual, what type of mechanisms or options are you looking at to ensure that they are raised in their culture or grounded in their culture, and all those types of things that you consider when you consider a child's identity. When applications or proceedings are made in the Family Court under the Care of Children Act, if there are safety concerns or if the court thinks it's necessary, they will appoint lawyer for child. So lawyer for child is a senior lawyer who's experienced in the Family Court. Their role in essence is to advocate for the child. So they are required to get the child's views and to report back to the courts about, what the kids want in terms of any decisions that are being made. So that's governed by Section 7 of the Act. It's also one of the principles in Section 5. So Section 5G is the principle about children or a child having the opportunity, and it needs to be a reasonable opportunity to participate in any decisions that are made about them. So if the family courts are considering changing their school or reducing or increasing the amount of time that they might spend with one family member or another, that child needs an opportunity to actually understand what decisions are being made, and what do they think about it? Would they support it? Do they like it? Are they happy with the current arrangements? That's really up to lawyer for child to get that information before the courts, and it's done in a way that is, as much as possible, will consider that child's age and their maturity. So obviously when you're getting the views of a 13-year-old compared to perhaps a 6-month baby, you're not able to have a conversation with a baby, but a 13-year-old might better be able to articulate how they feel about different decisions. So that's lawyer for child's role, or part of their role, in terms of the family court process and any decisions made under the Care of Children Act. When the courts are appointing a lawyer for child, as much as possible, they will try and match a lawyer who has either a background or experience that is similar to that child or to those children. And I think when you think about a lawyer advocating for children or for a child, it makes sense that their background should match as much as possible where possible, because there might be language barriers, or it might be easier for a child to connect with a lawyer for child who has a similar background. And an example of that might be a child whose primary language might not actually be English. So it might be about finding a lawyer who's able to communicate and articulate the decisions being made in court, and then get their views in their primary language, whether that's Māori or any other language that a child might speak. So that's just a really brief overview of lawyer for child's role, and how they fit, or where they fit in the family court process. that's just the overview of the principles and some of the functions of the family court process. Our next kōrero or our next chat, we're going to be talking and looking at parenting applications, what happens when care arrangements need to be resolved by the courts, including the different options of applying for parenting orders. Kia ora tātou. Kia ora tātou, kia ora anō tātou. My name is Waimirirangi. This is part 2 of the previous chat or the previous kōrero that I gave in terms of the family court, the principles and applications made under the Care of Children Act. So today I'm just going to talk a little bit about care arrangements and what happens when there is a dispute between guardians or between parents about what should happen with their children. So care arrangements naturally are things that mum and dad or parents and guardians will decide together. So you decide on who's going to care for the kids, when and where, based off of work schedules, other commitments, and that just naturally occurs between parents and guardians. Issues obviously arise when parents or guardians separate, or if there are just otherwise other views around how care arrangements should work. And then at that point you kind of want to look at what are your options to resolve that dispute. So the first piece of advice that I usually give to clients or to parties who come to me seeking advice, it would be to talk, which sounds really obvious, but actually having a discussion with the other parent, the other guardian or party is the first point, should be the first point. Actually trying to have a chat about the issue, see if you can reach agreement about some care arrangements. You can do that in person, you can do that via text message, Facebook message, phone call, any way essentially that you want to communicate with them, you can do whatever. If there are concerns about that approach, or if that approach is not appropriate, in some instances where it might not be appropriate is when there's too much conflict between the parties, so they're just at a point where they're like, no, can't reach agreement, we just do not see eye to eye, or if there's a lack of trust between parties or parents and guardians about what the care arrangements should be. At that point, we'd usually steer clients or parties to mediation. So in terms of family court proceedings and disputes that arise in the family court, FDR, which is Family Dispute Resolution, they manage mediation for parties in terms of those types of issues. So we'd usually refer clients to go engage in mediation. Mediation is a confidential, without prejudice process, which essentially means you can go in the room, have a chat with them, have a mediator there to facilitate that conversation, and you're not bound by anything that you talk about in that room. So nothing from that room can leave the room. It's confidential. You can't take it into an application in the courts. You can't discuss it outside of that process. The only thing that you can take out of mediation is any written agreements that you reach. So let's say you come together, you have a mediator who's facilitated mediation, and you have a written agreement you've both reviewed, or if there's more than two parties, all of you have reviewed the mediation agreement. If you're all happy with it, you sign it, and then that forms the basis of the care arrangements. Now, when clients go to mediation, I always tell them that it's really important to know that you are not required to sign anything. A mediator shouldn't be, and they're unlikely to, but they shouldn't be telling you that you have to reach agreement. If you don't feel comfortable or happy with the agreement that was reached, or if you feel pressured, or you just think, actually, I need some more time to think about this, then you are free to actually have that option to say, no, I'm not going to sign this. Mediation is a voluntary process, which means that even if you want to engage in mediation, but the other person or the other party doesn't, you can't compel them to go to mediation. So in terms of how you would start that process, you'd reach out to FDR, let them know this is the person I want to have a mediation with, and then they'll reach out to that person, and either they'll say, yep, I'm on board, let's do this, or they'll say, no, I don't want to engage in mediation. And at that point, you can usually get an exemption form, which is a form that says you tried, but they didn't want to engage. Or if you do engage and the parties or you and the other person don't reach agreement, then you'll get a form that says essentially that you went but you didn't reach agreement. And then the third and final step available to parties is to file an application in court. So under the Care of Children Act, you can apply for a parenting order. Parenting order, or what some people kind of know it by, is a custody order. That is kind of the old terminology that we use. So we use the term parenting order, which pretty much just means it's an order that says who cares for the kids, and if the other party isn't the primary carer, what do their contact provisions look like? So contact provisions, or contact, is just the term that we use to say, these are the times that you get to see your mum or your dad or nanny or auntie or whoever else is applying to the courts for contact with the kids. That's the basic functions of a parenting order. There's more details in terms of types of conditions you can include in a parenting order and provisions, but I won't get into that today. So when you do make an application for a parenting order, there are two different tracks that you can file your application. So the first track, or the most common track, is on notice. On notice just means it follows the standard process. So the requirements for filing on notice is that you must engage in mediation in FDR. You can apply to be exempt from that requirement, which is pretty much you asking the courts, hey, I know this is the requirement, but can you excuse me from having to tick this box? And they can either approve or refuse that application. And generally speaking, you would apply to be exempt from mediation if where it wouldn't be appropriate for you to be engaged in mediation because there's a history of family violence, and it wouldn't be safe for you to be in a room engaging in mediation with them. The other requirement for filing on notice is to complete a Parenting Through Separation course or program, which is provided by the Ministry of Justice. It's a free program, and to the best of my knowledge, it's 4 hours long, so you can do it in person or you can do 2 sessions in 2-hour blocks, and you also have the option to do it online. And the final requirement, or the final thing that you need, is to pay the filing fee, which is $251. But you can apply to have that filing fee waived if you are suffering from financial hardship. The other option, or the other avenue available to parties when they're filing applications, is to file a without notice application. So without notice applications operate much differently to on notice applications, whereas with on notice applications you have to meet all those requirements, and then the documents are processed in court, then the other party is served, they file a response. It kind of goes through that process. With a without notice application, it bypasses all of that. Essentially, your application would be filed on the day and considered on the day, if not that day, the following working day. And the only reason, or the only way that you can apply without notice, is if you meet the grounds or the test, the legal test. Yeah, the legal test for filing a without notice application is that you need to be able to demonstrate to the courts that any delay in filing or processing that application would cause or would risk undue harm or hardship to the child or to the children involved in the proceedings. So what that means in practice, or in reality, is you're saying to the courts, hey, I need you to consider this ASAP, because if you don't, there's a real genuine risk that the child or the children would suffer from harm or hardship, which might look like a number of things. So it could include exposure to, or ongoing exposure to, family violence. It could be exposure to adult conflict, so maybe the parents are unable to reach agreement and it's gone to the point where it's escalated and the kids are constantly being dragged or pulled into adult arguments. It might look like exposure to a parent or guardian who's under the influence of alcohol or drugs, not necessarily a drink, but excessive alcohol use to the point where it becomes a risk to the kids. Other examples or other things that might give rise to a without notice application would be neglect. So if the kids are just consistently missing school or their needs aren't being met, there needs to be some sort of immediate intervention. So when you make an application on a without notice basis, like I said, it bypasses all the requirements that you need to make an on notice application. So what that means is that the right of the respondent or the right of the other parent or guardian to be heard, which we kind of understand as being natural justice, that right is removed temporarily, or the child's safety is prioritised in lieu of that right to be heard. Usually an interim order will issue. So what that means is it's just like a temporary order. It's just a placeholder while things are settled, and while the courts and other parties trying to reach agreement about what's best for the kids. When you file an application on without notice basis, and actually when you file any application in the family courts, you're required to tell the truth, the full truth, and nothing but the truth. So what that means is you need to make full disclosures when you're doing without notice applications. So you need to disclose any criminal convictions, history of family violence, or other related things that might indicate to the courts that there's some concerns there. It's just really about giving all of the information that you can to the judge or to the court so that they can make an informed decision on that without notice platform. So those are the two different options in terms of the different applications or the different tracks that you can file an application for a parenting order. It's helpful to know that it's not just mum and dad or parents and guardians who can apply for parenting orders. So wider whānau members or friends in some instances of the whānau can apply for a parenting order. If you are not the mum or dad or the guardian of the child or the children, you need to seek leave of the court, which I'm going to say that part again. If you're not the mum or the father or the guardian of the child or children, you need to seek leave of the court to file for a parenting order. So you just need to ask the courts, hey, I have an interest in making this application. Can you please allow me to make this application? And so often we see nannies, koros, aunties, uncles will come in and they want to make an application for a parenting order to care for their niece or their nephew or their moko, because they can see that there's intervention that's needed to keep them safe, but also to keep them within the care of whānau. So yeah, that's just a little bit about how care arrangements are resolved, the approach and the options available to parties. And yeah, I think one final point that I will say is that all of the processes that we've talked about in today's chat still rely on all of the principles that were referred to in the first part of this series of kōrero, which is welfare and best interests is first and paramount consideration. So what is best for the kids or for the children? And all of the principles that we talked about, those are things that are taken into account when a decision is being made. So yeah, kia ora.